Ghana humbly invite the Honorable Attorney General and Minister of Justice and the official leader of the bar, Fred Yeboah Adame, to give us his address.
Thank you very much. Good morning. Leadership, the Chief Justice, this is Gertrude Araba Esaba Saki Tokonu, Justice of the Supreme Court, Justice of the Superior Court of Judicature, here in Garded, retired Justices of the Supreme Court, Justices Amegache and Jones Victor Maulo, which I agree to. Honorable Ministers of State, Members of Parliament, the President of the Ghana Bar Association, Sayawa Champon Bafo, the President of the Central Regional Bar, Deputy Attorney General Afretua Yeboah, members of the Bar Council, Dogwahine Osaberi Makwisiata II, as a question for the matter. Eminent clergy, members of the bar, distinguished ladies and gentlemen. It is a delight to be in the company of colleagues at the bar. The Bar Conference presents that rare opportunity to meet fellow lawyers from different walks of life, from Bolgatanga to Takoradi, whether we practice in commerce or crime, and whether we work in a public service or private practice. It reinforces my conviction that fundamentally, we are one bar and a strong one at that. Since the last Bar Conference in Ho, we have had a new Chief Justice in the person of Her Ladyship Justice Araba Esaba Saki Tokonu, the third woman to occupy the office and the 15th in the history of Ghana. I have no doubt that the repertoire of qualities, skills, and experience she possesses will place her in a position to continue the process of modernizing and transforming Ghana's judiciary. Congratulations, my lady. The bar, of which I'm the official leader, is in full support of your tenure, and I pledge the fullest cooperation of the Office of the Attorney General and Minister of Justice for you as well. May God be your guide as you superintend justice delivery in our great republic. Cape Coast, and I think I must also extend a happy birthday to you. And indeed, if I had, I'm sure some bouquet would have arrived at your door. It's never too late in this regard. Cape Coast represents many of the good things in law practice. The first capital of the Gold Coast and the hometown of the first indigenous lawyer of our land, John Mensah Saba. It is apt to say that Cape Coast is indeed the cradle of the law in Ghana. The first Supreme Court building is located a few miles away from this venue. And at this point, I may say that I'm aware of plans to construct a new High Court complex not too far away from Adisade College, as part of this government's agenda to deliver a set of modern and fit-for-purpose infrastructure for the judiciary throughout the country. Whilst not opposed to the idea of construction of a new High Court complex for the people of Cape Coast, I am of the view that we should also renovate and preserve the significance of that beautiful edifice, which once housed our Supreme Court as a historical monument for Ghana's judiciary. Most occupants of the highest echelons of power in our legal profession, the offices of the Chief Justice and the Attorney General, had their secondary education in Cape Coast. Many a lawyer obtained some lecturing from a Cape Coast high school. And I hope that lawyers gathered here will in the course of a week find time to undertake some outreach activity at their respective institutions. Personally, Cape Coast holds good sentiments for me as well. I did my primary education in Cape Coast, starting from class 1 at the Bressan Memorial Preparatory School, and continuing all the way up to secondary level at Adisade College, where I was part of the last batch of both the ordinary and advanced level candidates in 1994 and 1996, respectively. And in talking about Cape Coast's contribution to the law, it is fitting to recall that the flame of Adisade burns bright. I understand the Wesley Girls people fondly say quite rightly that they have produced the first three lady Chief Justices of Ghana. And congratulations, all three, that's good. But the record also shows But the record also shows that before Chief Justice Georgina Wood, the three of the immediate last 4 Chief Justices, and I talk about Philip Edward Archer, Edward Kwame Redu, and George Kingsley Archer, were all decided products. So indeed, the tree was blazed quite some time ago. And it's understandable why the new High Court will be located opposite Adisadel. That is where the law is. Colleagues, I was struck by the importance of the choice of theme by the bar for this year's conference, ensuring high standards of integrity in life, in public life, the role of the legal profession. It cannot be overstated that the legal profession indeed has a huge role to play in the setting of high standards and integrity in public life. The law, which members of this profession practice, consists of a set system of rules by which a particular country or community regulates the actions of its members and which it may enforce by way of penalties. The bar, of course, has always had close links with public life. The history of the land on which we live has seen a very intimate dependence on the law. The acquisition of the Gold Coast by the British and the manner in which the British chose to regulate their relationship with the indigenous people depended on law. After independence, law continued to shape the policies and visions of successive governments, dreams and aspirations of the people. Every new administration has been ushered in by law. Even the military regimes that abrogate the constitution have been quick to put in place various military decrees to regulate their reigns as well as to formally abrogate the old constitutions. The political architecture of our country is a creation of the law. Ghana is built on a legal instrument, the Constitution, approved by a national referendum in April 1992. The election of the president every 4 years is always validated by the publication of a law, the constitutional instrument titled a Declaration of President-elect Instrument. In driving home the preeminence of the law in the affairs of state, I cannot help but quote once again the immortal words of Justice Azukrab, former Chief Justice, at the time of the celebration of the centenary of the establishment of the Supreme Court in 1976. And it goes as follows. If our legal history has been eventful in this past century, we can only say that we have been lucky in the people of our nation who have been alive in every generation to match the grandeur of the events of the time. We have in these past years never needed a hero in the law to speak up for our people. A Castle Hitford to warn the imperial power to keep our lands inviolate. A Mesa Saba to plead the people's cause in the highest councils of empire. A Kuse to guide in the writing of our first constitution towards independence. In our own lifetime, a Dankwa to keep us reminded of the need for legal self-discipline in the tumultuous years immediately after independence. And a Kosa to hold first among our people the scales of justice evenly between the government, legislature, and the people. End of quote. Throughout much of the history of post-independence Ghana, there has been a shared culture between the bar and the higher reaches of government and the civil service. There has never been a gulf between the worlds of law and politics. A very large number of practicing barristers have been members of the House of Parliament. The speakers of Parliament Ghana has had so far have been lawyers. The Fourth Republic has seen 3 of its 5 presidents so far being lawyers. Unfortunately, it looks like the next president will not be a lawyer. However, it is becoming increasingly quite clear that even though the next president will be an economist, being the son of a lawyer, even though the next president, in my view, would definitely be an economist, being the son of a lawyer, he will hold fast to the values the legal profession cherishes. If lawyers have played this prominent role in the building and development of our country, then their role in the maintenance of standards and the promotion of integrity in public life cannot be taken for granted. The significance of integrity is summed up in the famous words of former U.S. Senator Alan K. Simpson, and it goes as follows. If you have integrity, nothing else matters. If you do not have integrity, nothing else matters. End of quote. In these words, the importance and indispensability of integrity in every situation we find ourselves in as human beings, including our public life, is brought to the fore. As lawyers, the rules of our profession, which bind us up with the discharge of a 5-fold duty to the client, the court, the opponent, to the lawyer's own self, and ultimately to the state, as stated by Lord Macmillan, a former Advocate General of Scotland and former member of the House of Lords, are founded on integrity and placed us in a position to ensure the maintenance of high standards in public life. Colleagues, in my respectful view, the Legal Profession, Professional Conduct and Etiquette Rules 2020, LI 2423, is carefully designed to serve as a signpost for high standards and integrity in the public service for every lawyer. Rule 1 of LI 2423 says that the lawyer's duty to discharge his responsibilities toward the client, the court, the public, and another lawyer honorably and with integrity. In the same rule, we find the lawyer's responsibility in view of the important role of the legal profession in a free democratic society to recognize the diversity of the Ghanaian community, to protect the dignity of individuals, and to respect human rights enforced in the country. Rule 5 of LI 2423 teaches us that the representation by a lawyer, that lawyer is, and I quote, a representative of a client, an officer of the legal system, and a public citizen with special responsibility for the delivery of quality justice, end of quote. Quite importantly, and I've often spoken about this, by dint of Rule 12, Sub-Rule 1, a lawyer is prohibited in the course of his professional practice from sending written correspondence or communicating orally with another lawyer in a manner that is abusive, offensive, or inconsistent with the proper conduct of a professional communication from a lawyer. Rule 14, Sub-Rule 2, further prohibits a lawyer from making a communication that is false or misleading if that communication amounts to a material misrepresentation of a fact or law. This rarely applies to lawyers who are constant users of or communicators on social media and the traditional media. It is abundantly clear from these rules that the age-old requirements of a profession, insofar as ethics is concerned, apply to lawyers on social media. Indeed, technology did not eradicate ethics. Rule 34 dictates that every lawyer shall make reasonable efforts to expedite litigation. As you can imagine, this is of interest to me. The considerably slow pace of justice delivery in Ghana hampers productivity and progress in many spheres of the nation's life. In accordance with Rule 34, it is the duty of every lawyer to expedite litigation. One justice delivery, which requires urgent injection of expedition and efficiency, is criminal justice. I have recently presented to Cabinet a criminal procedure amendment bill, which introduces a substantial reform of the criminal procedure laws of this country, with the ultimate objective of enhancing the speed of adjudication in criminal cases. The new measures proposed include scrapping trials on indictment, except where the offense is punishable by death or life imprisonment, as enshrined in the Constitution or other substantive law. Submission of witnesses by video conference, trials to proceed. An accused person is not personally present in court. Day-to-day trial of all criminal cases, except where same is impracticable. Restriction on interlocutory appeals to only after a determination by the trial court of a submission of no case by the accused. Reform of the jury system to reduce the list of exemptions from jury service. And I think I must indicate that going forward, lawyers will serve as jurors. The composition of the jury by the introduction of the concept of alternate jurors, adoption of proceedings in criminal cases, and many other matters. The bill underwent extensive stakeholder consultations prior to its presentation in Cabinet, and I note with satisfaction that the Judicial Council and the Ghana Bar Association have approved of those far-reaching reforms of criminal procedure in Ghana. I'm hopeful that Cabinet will deliberate on same rapidly in order for it to be laid in Parliament when parliamentary sittings resume in October. Respectfully, at the heart of the legal profession are three commitments: to independence, to excellence, and to advocacy. These three tenets, combined with the bar's high degree of tenacity, explain why the bar has survived in Ghana since 1876, and why, in my view, it will continue to survive and thrive. We should not take these things for granted. The essential elements of a profession must be guarded against elements who seek to destroy same. Lawyers must fearlessly speak against tendencies which threaten the integrity of our profession. Fearlessness, indeed, is an age-old attribute of the good advocate. Rule 52 of LI 2423 specifically restrains lawyers from making statements which they know to be false or with reckless disregard for their falsity concerning the integrity of a judge, an adjudicative officer, or a public legal officer. Rule 61 paragraph B, subparagraph III, proceeds to further bar lawyers from engaging in conduct which diminishes confidence in the administration of justice. We cannot turn a blind eye to the reality that has become customary for some people, indeed is an annual affair, to launch unwarranted attacks on the independence of the judiciary. If the source of the recent attacks on the independence of the judiciary is of concern, of even greater worry is a class of people who provide audience for such unwarranted comments to be made. The audience consisted of lawyers. It is worrying because, as I've stated before, lawyers ought to be the loudest and strongest defenders of the independence, integrity, and importance of the judiciary, rather than serving as tools for its destruction. By their silence, they became arbiters in the propagation of hate against the judiciary. For one to express the desire to appoint mainly members of one's political party to the judiciary, if given the mandate to govern the nation again, clearly indicates an unfamiliarity with the process of appointment of judges. Whilst acknowledging the constitutional duty of the president to appoint all judges in the country, it is imperative to note that the president does not appoint judges to any court in a vacuum, or in that regard. Each appointment onto the judiciary is preceded first by an indication of a vacancy by the Judicial Council. Without a vacancy, the president cannot appoint. We cannot in this regard rule out the coincidence of situations. If a vacancy arises, it falls for whichever president is in office to formally fill same by appointing after the exhaustion of all constitutionally mandated procedures. Thus, the notion that the president can just appoint any number of judges that he desires in order to neutralize, in quote, the perceived declaration of the judiciary is incorrect and grossly misleading. Further, the participation of the Judicial Council as well as the Council of State and Parliament, where necessary, in the processes of appointing a judge stipulated in Article 144 of the Constitution cannot be ignored. The President also does not have the power to empanel any court in the country. Respectfully, a consequence of the government's policy to expand and improve infrastructure of the judiciary through the construction of over 100 high court buildings around the country and the Court of Appeal complex in Kumasi, which has 20 four-bedroom bungalows, has been the need to appoint and post judges to some of these courts. It may well be that the criticism the sitting president enjoys or receives from certain quarters for the alleged appointment of many judges to the Superior Court is a price the government is paying for improving access to justice and improving judicial infrastructure. It has perhaps become necessary to examine critically the number of appointments made onto the highest court of Ghana, the Supreme Court, since 2009. The record shows 7 appointments to fill 7 vacancies on the Supreme Court between 2009 and 2016. I take note that there have been 15 appointments to the Supreme Court between 2018 and 2023. However, a careful scrutiny of those appointments shows that they actually filled only 6 vacancies, positions held by Justices Mafusel, Agnes Doji, Lena Megache, Professor Kote, and Clemens Holinega, all of them being appointees for President Kufuor, became vacant in the course of the same president on account of either death or retirement. And indeed, another justice appointed by President Kufuor will also retire this year, Justice Mariam Owusu. With such vacancies, fresh appointments have to be made. It is important that we remain resolute in our defense of the judiciary at all times. Ghana has gained a worldwide reputation for its justice system and legal services. The justice system, of which the bar is an integral part, is the glue that holds the society together. Decisions of our Superior Courts are cited in cases in other jurisdictions. Our courts are recognized throughout the world for their excellence, openness to innovation, and willingness to break away from conventions where necessary. For those who cannot come to terms with significant defeats in the courts of law, it ought to be understood that the courts administer justice according to law. The court, as I always say, is not a mercy chamber to serve justice based on affection or sympathy. I have stated before that as Attorney General, I have not had every ruling on cases contested by me in the courts go in my favor. When rulings adverse to my interests are given against me, I do not go on a rampage attacking the court or releasing press statements to criticize those decisions. I sit back, reflect, dig deep into my legal arsenal, and deploy processes known to the procedural laws of the country to reverse him. On some occasions, I may not even succeed at all, but I live with the decisions and the consequences of them. Indeed, when I look back at certain cases whose outcomes I consider undesirable, regardless of my own views on the questions being judged in them, I come to the conclusion that we have in this country a fiercely independent judiciary in which all of us should take pride that an aggrieved citizen can go to a court of law and challenge anyone, including decisions of the president and parliament, and be confident that the court will give a decision without fear or favor. And I refer to recent decisions of the Supreme Court in the Ghana Center for Democratic Development and 8 others against the Attorney General, Ezra Manan against the Attorney General, and Professor Appiah J. Tutua against the Attorney General. There cannot be a bigger avenue for a lawyer to demonstrate high standards and integrity in society than service in the public sector. Indeed, the historic office of the Attorney General, whose functions are to advise the government impartially, provide counsel to it, prosecute crime in the country, and assist the draft of legislation, plays the role of a critical friend to government. On assumption of office, I signal the dispensation whereby the Office of the Attorney General zealously protects the interests of the state in litigation, just as private legal practitioners do for their clients, and become the standard bearer in the practice of law. I'm happy to note that through the sound legal advice we give to various ministries, departments, and agencies, we have averted huge judgment debts and spared the nation a lot of agony in other cases. Where cases end up in litigation, the litigating capacity of the Office of the Attorney General has been immensely boosted to the point where the state now enjoys tremendous success in most civil litigation, including international arbitration and cases in foreign courts and tribunals. Such is the strength of the capacity of the Office of the Attorney General that now memorials, pleadings, and written submissions filed by the office compare favorably with those filed by any lawyer on the international stage, and where the state has been holding its own in most international arbitrations and cases in international courts, and most of the time without the aid of foreign counsel. It is only when the peculiar circumstances of Indeed, it is only when the peculiar circumstances of a matter necessitate that recourse is had to foreign counsel that indeed we do so. Both domestically and internationally, since the last conference, notable successes that have led to a state saving amounts the equivalent of billions of United States dollars from judgment debts have been sought by the Office of the Attorney General and Minister of Justice. As part of the process of reform of the Minister of Justice, I recently authored a letter to the Minister for Finance requesting that he considers paying to my office a small percentage of the amount realized in those cases. This will go a very long way to address the liquidity challenges of the office. And it should be noted that this request does not even cover the huge judgment debts that we save, which no one takes note of, but which, of course, runs into billions of US dollars. But it's also a request that I'm here to receive a response from the Minister of Finance on. My lady, the prosecution division has also ably lived up to its constitutional duty of being the prosecutor of all crimes in the country, even though prosecution of so-called high-profile criminal cases is thwarted by unjustified delays occasioned by the filing of unnecessary interlocutory applications and various frivolous appeals. The efficiency of a nation's justice system is tested by the manner in which cases seeking to hold high-profile members to account are conducted. It's unfair for so-called high-profile criminal cases involving the scheme of fraud, which causing financial state and money laundering to drag on for years, while similar cases filed against the perceived ordinary members of society are concluded within 6 months to 1 year. There is clearly a need for legislative reform, and that is why the Criminal Procedure Amendment Bill I spoke about earlier on is very, very important, and I request the bar to lend its maximum support. On this call too, I'm happy to say that the legislative drafting division of my ministry has been most helpful. Since the last conference, there has been the enactment of some important pieces of legislation to strengthen accountability and promote integrity in Ghana. There has been a strengthening of the whistleblower regime by the enactment of an amendment of the Whistleblower Act 2006 at 720 to introduce a reward system for whistleblowers. The new amendment passed by Parliament only about a month ago ensures that 30% of all revenue accruing from cases conducted on the strength of whistleblowers' activity is paid into the fund, and 10% of the income directly generated by the whistleblower's efforts is paid to a whistleblower. Some time ago, I bemoaned the inimical tendency on the part of public officers to enter into contracts with high rates of interest, especially compound interest. In order to curb this tendency, my ministry has successfully sponsored the enactment of an amendment to the Contract Act of 1960 at 25 to prohibit the payment of compound interest by the state in transactions entered into on her behalf by public officers. Henceforth, it will be unlawful for any public officer to enter into a contract in which the rate of interest is stipulated to be compound interest. The state's hard-pressed purse will be further protected by this amendment to the Contract Act. The Ministry of Justice is working on a few other important bills as well. I consider the passage of an Alternative Sentencing Act an urgent necessity as a further avenue to reduce congestion in our prisons. A revised draft community sentencing bill prepared by my office is going through a process of validation by stakeholders and will soon be laid before Parliament. When account is taken of the sublime role played by state attorneys as counsel to the Republic, it is necessary that the human resource capacity of personnel of the Ministry of Justice be boosted so as to ensure that they deliver first-class world standard service to the nation. In this regard, a partnership between Georgetown University, Washington, D.C., and the government of Ghana, represented by the Attorney General, executed by my good self in September 2021, seeks to ensure that each year 5 lawyers would benefit from postgraduate legal education sponsored by a scholarship jointly funded by Georgetown University and the Scholarship Secretariat of Ghana. It is pertinent to indicate that the first batch of 5 lawyers who profited from this arrangement have returned upon successful completion of their programs. Even though I must hasten to say that with the experience I encountered with the Scholarship Secretariat in terms of delayed payment and incessant complaint by Georgetown over persistent failure of the Scholarship Secretariat to pay their portion of the scholarship, I find it a little bit reluctant to even proceed with the scheme. In addition to this, state attorneys regularly proceed to pursue various academic courses sponsored by some state institutions relevant to their roles. I cannot conclude this address without emphasizing that there's a need for us to build a world-class legal service in Ghana, working as part of an open global community to resolve modern-day disputes, many of which have cross-border elements. As a profession, we cannot stand still, nor would we want to do so. We need to move with the times just as the rest of society does. But this does not and should not mean change or innovation for the sake of it. Upheavals and disruptions not in tune with the needs of the times are undesirable. The bar is not without its problems, but let us not forget that the law is an endlessly stimulating profession. It is serious and fun at the same time. May God help us to continue to build for Ghana a nation founded on the rule of law, grounded in high standards of integrity and respect for fundamental human rights. Thank you very much. God bless us all.